Good day, everyone, especially to you, Dr. Kiber. My name is Jeah, and I'm going to talk about the chapter 3, which talks about the laws and obligations and contracts. And before anything else, I will be providing to you first the topic outline and the objectives for this lesson. So for the topic outline, we do have first the introduction to obligations and contracts, key elements of obligation, sources of obligation, case study with the disastrous conference, legal analysis of breach and liability, legal remedies and liquidated damages, introduction to the suspension of the power to sell, modes of extinguishing obligations, payment in different forms, fortuitous event, and contracts and legal definitions. So for objectives, is to understand the basic concepts of obligations and contracts in the context of business. Second is to identify the key elements that constitute an obligation. Third is analyze real-life scenarios where obligations and contracts are affected by unforeseen circumstances. Next is understand the legal implications of breach of contract, including fraud, negligence, and delay. Explore legal remedies available in case of contract breach, including penalties and liquidated damages. Learn the various modes through which obligations can be extinguished under civil code, including payment loss and novation. Recognize other causes of extinguishment, such as death, fortuitous event, and the implications for obligations in contracts like partnerships and agency. And lastly, understand the essential elements that constitute a valid contract. So these are the topics and the objectives that we're going to look forward with regards to our lesson for today. So the introduction of obligations and contracts is it introduces the topic of law and obligation and contracts, which is a fundamental part of business law. So this subtitle highlights the relevance of understanding the legal framework in business transactions, ensuring that participants recognize the importance of the subject matter. Obligations are legal duties or responsibilities that bind parties together, compelling them to give, do, or refrain from doing something. A judicial necessity to give, to do, or not to do something. It can arise from contracts, laws, or acts punishable by law. So for that, an obligation is also a legal duty that compels a person to give, do, or refrain from doing something. This is a very critical aspect of any business relationship as it dictates the responsibilities of each party involved. While contracts, on the other hand, are formal agreements between parties that set out terms and conditions for obligations. These are formal agreements between parties that outlines the terms of their obligations, and it emphasizes that without a clear understanding of these concepts, business operations can be risky and prone to legal disputes because it needs to have a proper contract for every agreement that the businesses may have. So here are the key elements of obligation. First, active subject or creditor. The person or entity entitled to demand the fulfillment of the obligation. So this is the person who holds the right to demand that the obligation is fulfilled. Second is the passive subject or the debtor. This is the person or entity bound to fulfill the obligation. So it is a person who is obligated to fulfill the duty, whether it's giving something, doing something, or refraining from an action. Next is a prestation, the specific act or object that is the subject of the obligation. For example, like a thing, a service, or an act. So, it is the object or action that the debtor is bound to deliver, perform, or refrain from. Lastly is the juridical tie, the legal bond that connects the active and passive subjects, typically arising from a contract or law. So, from the words itself, a juridical tie. So it's a connection, a legal connection between the parties which arises from either a contract, law, or other legal agreements. It is what makes the obligation enforceable in a court of law. So understanding these elements is crucial because it clarifies who has the right to enforce the obligation and who is responsible for fulfilling it. So next, we do have the sources of obligation. So it will explain the different origins of obligations. So first is law. Obligations that are automatically imposed by law, such as paying taxes or following regulations. So these are obligations mandated by the legal statutes. Next is we have the contracts. These are voluntary agreements that bind parties to specific terms. So these are voluntary agreements between two or more parties, like business contracts or service agreements. Next is the quasi-contracts. These are obligations that arise even without a formal contract, often to prevent unjust enrichment. So these arise without a formal agreement but are recognized by law to prevent unjust enrichment. For example, paying for goods delivered by mistake. So that is an example of quasi-contract. It doesn't have any formal agreement, but it still does show some evidences that you can provide to and are still recognized by the law to prevent unjust enrichment. Next is an acts punishable by law. So these are obligations stemming from criminal acts. So that is when a person commits an act that violates the law, they create an obligation to compensate for the harm done. For example, a person who causes an accident must compensate the victim. And lastly, quasi-delicts. These are faulty actions that cause harm and create liability. So quasi-delicts are similar to torts. So these are actions that cause harm through negligence or fault without an intention to harm. So it's like you are unintentionally or you did intentionally harm a specific party. For like example, a person negligently injures another even without a contract. So for this one, these sources of obligation emphasizes that obligations don't always arise from formal agreements, making it essential to understand all the possible sources of liability. So here's a quick case study with the disastrous conference. So a background is just a small background or scenario for this case study. There's a university organized a conference in Manila, but a typhoon impacted attendance. The organizer had paid a deposit for banquet meals, and the hotel had prepared food for 400 people, but only 50 showed up because of the typhoon. So, key questions. Does the organizer need to pay for the meals not consumed? Second, what are the obligations of the hotel and the organizer? Third, can the organizer request any concessions? So for this one, we're going to take a look with the legal analysis of the conference case. Should the organizer pay the full amount for the meals? Can the hotel legally charge for meals not consumed? And what concessions can the organizer request? So for this one, we'll be discussing a real-world example to illustrate the practical application of obligations and contracts. So the case involves a university organizing a conference where unexpected circumstances, such as a typhoon that has affected the low attendance for that event, in which it challenges the agreement between the organizer and the hotel. So for this one, we're going through the legal analysis of the conference case. So the first question, should the organizer pay the full amount for meals? So for this one, the organizer could argue that the full payment should be adjusted due to the low number of attendees, especially considering the force majeure or the typhoon. However, if the contract specifically states that the number of meals to be paid for, the hotel may be within its rights to charge for the full amount because it has a contract that will be stating the specific scenario that is already provided also in the contract if there will be some unforeseen circumstances. So next, can the hotel legally charge for meals not consumed? So the hotel can charge the agreed upon amount unless a provision allows for adjustment in case of low attendance or exceptional circumstances like a natural disaster. So third, what concessions can the organizer request? So for this one, the organizer might request a reduction in charges or compensation for unused meals, or renegotiate the future events under similar circumstances. So this underscores the importance of having clear cancellation or adjustment clauses in every contract. Okay, next, so we'll be tackling about the breach of contract and liability. So first is fraud, an intentional deception to evade the fulfillment of an obligation. So fraud occurs when one party intentionally deceives another to avoid fulfilling their contractual obligations. For instance, if someone misrepresents their capabilities or intentions in a contract, so that happens, or that is fraud. Next is we do have negligence. Negligence is failure to exercise the necessary diligence, resulting in damage or loss, common in contracts like transportation. So next is delay. Failure to perform an obligation on time. Legal remedies such as claims for damages may be available after a formal demand is made. So delay. If a party does not perform their obligations on time, they may be held liable for damages unless the contract stipulates otherwise. So this highlights the importance of adhering to deadlines and having clauses that specify the consequences of delays. So it is very important that every contract must be comprehensive and full of details, especially very specific, especially in adding or providing clauses with different circumstances. So I'll be providing you a quick case study. For this one, it's Dr. Pablo's luggage issue. So Dr. Pablo's luggage was delayed, leading her to miss a United Nations meeting. So with regards to that, she is entitled to nominal damages for the distress caused by the airline's negligence. So for this one, Dr. Pablo's luggage was delayed by the airline, causing her to miss an important meeting. This case highlights negligence by the airline and the entitlement to damages for the inconvenience and distress caused by their failure, because Dr. Pablo wasn't able to attend the meeting because some of the files and the papers was in the luggage that has been separated from traveling with her, and it was shipped also by a separate plane, in which it has resulted to the delay of the package or the delay of the luggage. So next is the suspension of power to sell. So the purpose of suspending the power to sell is to ensure that the protection of both parties in the contract, particularly in cases of unforeseen circumstances. So this temporary suspension is not intended to harm either party, but to provide a safeguard for the corporation and the parties involved. So suspension aims to avoid unfair advantage during times when it is not possible for one party to fulfill their obligations due to circumstances beyond their control. So for this one, we have key points with regards to suspension. So suspension is beneficial and reasonable. It's a temporary justified measure to protect both parties. It also safeguards the interests of both parties. The suspension aims to balance the rights and obligations during unpredictable situations. And lastly, it protects also during unforeseen circumstances. By suspending the power to sell, the corporation and parties are shielded from harm caused by events that may affect the contract's performance. So next is the modes of extinguishing obligations from Article 1231. So under Article 1231 of the Civil Code of the Philippines, obligations can be extinguished in various ways. So these are like legally recognized methods that end a party's responsibility to perform an obligation. So the key points for this are the payment or performance, the loss of the thing due, condemnation or remission, confusion or merger, and compensation. So for payment or performance, obligation is extinguished when the debtor fulfills it as agreed upon in the contract. And loss of the thing due is if the object or subject of the obligation is lost and it cannot be performed, the obligation ceases. Third, condonation or remission. The creditor voluntarily forgives or cancels the debt, thereby extinguishing the obligation. Fourth is confusion or merger. It is when the roles of debtor and creditor merge. So, example, if both parties become the same person. So, it's merging. And fifth is the compensation, which is extinguishment of obligations through the offsetting of mutual debts between parties. And lastly, the novation, in which replacing an existing contract with a new one, thus extinguishing the original obligation. So there are also other causes of extinguishment, such as death, where obligations that are purely personal, like partnership or agency contracts, are extinguished by the death of one party. And also is a fortuitous event or force majeure. It refers to extraordinary, unforeseen circumstances that prevent a party from performing their obligations. For example, like natural disasters like earthquakes and floods, or human acts like wars or strikes that render performance impossible can lead to the extinguishment of obligations. So, for example, if a store is supposed to deliver goods to a customer but the goods are destroyed in a natural disaster, so the obligation might end because it's impossible for the seller to perform the delivery. Next is we do have the payment and currency. Payment must be made in the legal tender. First is the legal tender. So payments must be in the official currency unless otherwise stipulated in the contract. So we need to follow what currency is stated in the contract when making a payment. So payments must be made using the official money of the country unless the contract says otherwise. Next are checks. Managers or cashier's checks are valid forms of payment but are only effective when they are cleared by the collecting bank. So checks like a manager's or cashier's checks are valid as long as they are processed properly by the bank. So next is we do have credit cards. So payments made by credit card are treated as a third-party payment. So this means that the debtor is still required to reimburse the credit card company who performs the payment on their behalf. So it means that if you use a credit card to pay, it means that you are borrowing money from the credit card company. You still owe that money, but the creditor is paid immediately. So next is fortuitous events or force majeure. A fortuitous event refers to extraordinary events that are unforeseeable and avoidable. The debtor is generally exempt from the liability if the event makes it impossible to fulfill the obligations. So it involves events that cannot be foreseen or avoided, such as natural disasters like earthquakes, floods, or man-made events like wars and strikes. So these are events that are beyond the control of the parties involved, and the debtor is not liable for obligations that they cannot fulfill due to these events. For example, as what I've mentioned earlier, a debtor who cannot deliver goods due to a natural disaster or an armed conflict is exempt from liability. So we also have like a quick case study for Philippines airline hijacking. So as short explanation, the airline's defense is based on the argument that the hijacking was an unforeseen and uncontrollable event. So here are the incident details. A hijacking occurred mid-flight with the armed individuals taking control of the plane, and the airline was unable to prevent the attack. So for the airline's defense, the airline argued that the hijacking was a force majeure event as it was beyond their control and could not have been foreseen or prevented. So the court ruled that the airline was not liable for the loss of property during the hijacking as it was case of force majeure. So it's not intentional. They cannot control it since hijacking is an unforeseen event. So next is contracts. These are legally binding agreements between parties, and they are formed when two or more parties meet to agree on obligations that will be performed in exchange for something of value. So from Article 1305, it defines that a contract is a meeting of minds between two or more persons where one party agrees to give or do something for the other party. Also, it is binding in nature, in which contracts create mutual obligations that are enforceable by law. Failure to comply with the terms of a contract can result in legal consequences for the breaching party. Next, what is an obligation? So we're going to review what we have tackled for the past lessons. So what is an obligation? So an obligation is a duty that someone is required to do or not to do according to the law. And what is a contract? A contract is an agreement between two or more people or businesses where they agree to certain terms and conditions. And what is the role of the civil code? So the civil code is a law that sets out rules for making contracts and obligations legally binding. So it is very important that understanding these concepts helps in both businesses and everyday life, because contracts are involved in almost everything that we do, like buying goods, renting a house, or making agreements. It's very crucial and important for us to know and understand the ways and the processes and the inclusions or the right things that the contracts or the right power of what a contract holds. So, essential elements of a contract. So, consent. Both parties must agree to the contract. So, it should have a proper consent. For example, they must offer and accept terms. So it should be both parties that should agree with the terms and conditions in the contract. Next is object certain. The thing or subject matter of the contract must be clearly identified. Example, for what you're buying or selling. So you need to be certain, or you need to know clearly or identify clearly what you're buying or selling. Next is cause of obligation. So the reason behind the contract must be legal and fair. So you need to know the cause. It can't be for something illegal. It should be legal, with due and legal processes. So all of these three elements must be present for the contract to be valid and enforceable. Next, contract of adhesion. A contract where one party creates most of the terms and the other party has little to no ability to negotiate. Example, like insurance policies, rental agreements, or service contracts. So, if we look at it in a legal perspective, while these contracts might seem unfair to the party that didn't write them, they will still be enforceable if the other party agrees to them. And it is very important to know that even if one party doesn't negotiate the terms, they still have the right to accept or reject the contract. So we do have the characteristics of a contract. First is the mutuality. So both parties must be equally bound by the agreement. So it should be agreed upon with both parties. And next is autonomy. Parties can make their own terms as long as they follow the law. And lastly, relativity is only the parties who sign the contract are bound by it, except in some special cases. And also obligatory force. Once signed, the contract must be followed by both parties. So these principles ensure that fairness, allow freedom in negotiation, and make sure that the contract can be enforced by law. Next is the sources of obligations. So for law, some obligations are created by laws. For example, like paying taxes. It is included in our law that there will be a fixed amount or fixed percentage that you need to pay with your taxes. Next is contracts. Most obligations come from agreements between people or businesses. For example, sales contract. Next is quasi-contracts. Sometimes, even without an agreement, the law creates obligations to prevent one party from benefiting unfairly at another's expense. For example, paying for goods that you received by mistake. So it is very important to know that obligation can come from many places like laws, contracts, or even situations where one party should repay another to avoid unjust enrichment. Next is the classification of obligations. First, we have pure versus conditional. A pure obligation is immediate, while a conditional obligation depends on an event that is happening. For example, I'll pay you if I get paid first. That is conditional. Next is obligations with a period. These obligations must be done within a certain time frame. For example, paying by a specific date, like, I will pay you by the 10th, something like that. Next is joint versus solidary obligation. In a joint obligation, each party shares part of the responsibility. But in a solidary obligation, one party can be held fully responsible for the entire obligation. So joint is more like the teamwork. Solidarity is only for one person. One person will be fully liable and responsible for it. Next is divisible versus indivisible. Divisible obligations can be split between multiple people, while indivisible must be done by one person. Example, paying for a single item. And lastly, obligations with a penal clause. Some contracts include penalties if a party fails to meet its obligation. For example, paying extra if you miss a deadline, or like paying an interest if it's already due. So those are the classifications of obligations, 5 of it. Next is we do have the types of obligations. First is pure obligation. A pure obligation is a simple promise to do something the right way. For example, I'll pay you $1,000 today, $1,000. So it's a pure obligation since it's a simple promise. Next is a conditional obligation. Something that happens only if a certain conditions are met. For example, I'll pay you if I get the job, or I'll pay you if I have a bonus. Next is obligation with a period. A promise to do something by a certain time. For example, I'll pay you by next Monday, or I'll pay you at or on the 30th. Next is joint versus solidary obligation, which shows different ways multiple parties can share or be fully responsible for an obligation. So for this one, these examples help to see how obligations work in different situations and clarify their respective responsibilities. And next is the autonomy and relativity of contracts. Autonomy. You are free to make your own terms in a contract as long as they follow the law. While the relativity is a contract only affects the people who signed it unless there are special conditions like insurance beneficiaries. And it's very important that these principles allow freedom in creating contracts while keeping them fair and focused on the people who agreed to them. And next, we do have the consensuality and the obligation to perform. Consensuality. It is a contract is made when both parties agree to its term. Next is obligatory force, that once agreed upon, both parties must fulfill their obligations and the law can enforce this. So lastly, we also do have the classification of contracts, which has preparatory, principal, and accessory. Contracts can be preliminary, before the main contract, independent, the main contract, or dependent that is related to another contract. Next is contract can also be consensual, real, common, and special. These are different types of the contracts based on how they're formed of what's required. And also contracts can be bilateral and unilateral. Some contracts involve promises from both sides, which is bilateral, while others only involve one side, like unilateral. So, lastly, it's onerous and gratuitous. That is, some contracts involve a mutual exchange, onerous, while others involve giving without expecting anything in return, which is gratuitous. So, understanding how obligations and contracts work is very essential for making informed decisions in legal and business situations. Knowing the law helps avoid problems and ensures that agreements are legally binding. So for this one, understanding the importance of consent, object, and cause in contracts, as well as the various types of obligations and contract clarifications will be important and is essential for making informed decisions in legal and business situations. So the conclusion reinforces that knowing the law helps avoid problems and ensures that agreements are legally binding. And that would be all for my report for the chapter 3. I hope you have learned something. Thank you so much for listening and have a great day.